Well, after an injunction imposed last June, a federal appeals court hears a challenge to Missouri's pro-life law. It prohibits abortion at or after 8 weeks of pregnancy. It also outlaws abortion for Down syndrome diagnosis. A full court ruling could take several weeks. And as reported yesterday, the Supreme Court has announced that it will hear arguments in a crucial pro-life case in early December. Dobbs versus Jackson Women's Health Organization is a Mississippi case seen as a direct challenge to the abortion precedent of Roe versus Wade. The court is expected to consider several other cases regarding religious freedom. And joining me now is Andrea Picciotti-Bayer, director of the Conscious Project. Andrea, great to see you. Welcome back. We'll get to the oral arguments in the Dobbs versus Jackson Women's Health in just a minute. But first, I want to get your thoughts on the lawsuit in Texas filed against the doctor who said that he actually performed an abortion in defiance of the state's new heartbeat law.
Well, it's an amazing thing how this issue around abortion really does inspire people to seek publicity. And I think there's nothing virtuous at all about flaunting the rule of law and basically asking for lawsuits. And I think it's probably best that everyone just kind of look the other way and say this is something that's going to be dealt with in the courts, and we don't want any spotlight seekers to ruin a clear review of the case and of the challenges.
Yeah, and how do you think this is all going to play out eventually with that?
You know, it's very interesting. I do think that the Dobbs case is probably better teed up for the courts to look at and to be able to analyze kind of in a calm fashion with briefing and without kind of the back and forth and the unique aspects of the Texas law. It does seem that there are very strong and cogent arguments saying that now's the time to revisit Roe and Casey. And I really do think that the word from the Supreme Court is really going to guide what happens next in these other cases and with regard to these other laws.
Yeah, and speaking of Dobbs, we're going to go back to that. Oral arguments are set for December 1st. Can you remind us again about the Dobbs case, what the lawsuit says, and what oral arguments could provide? Could they provide any clues on how the justices may rule?
Absolutely. Well, first off, I want to say there's great news that the Supreme Court will be holding in-person oral arguments. Last term, it was remote by telephone for the advocates. So now the advocates can go and present their case and have kind of that vibrant back and forth with the justices. It will be closed to the public, but I'm sure there are going to be a number of people both supporting Mississippi's law in the Dobbs case and opposing it, promoting abortion on the courthouse steps. So that will be an interesting case to look at. It involves the Mississippi law. Mississippi has a gestational age law that prohibits abortion, elective abortion, after 15 weeks of gestation, except in the case of medical emergency or severe fetal defect. The issue is really going back to first steps. Has the abortion jurisprudence of the courts really come with unintended consequences? It's really gone off the rails. There's been a lot of advances that we've learned both in medicine about the human person and their development, and the advocates are really asking, let's go back and reassess things. What's very interesting, Tracy, is Beckett Law added an amicus brief and said if the court pulls back and recenters itself on this abortion issue, the number of ancillary cases affecting religious liberty will be resolved. So with its unrestricted abortion jurisprudence, lots of religious freedom issues have come up since Roe versus Wade and since Casey.
Yeah, and speaking of religious liberty, religious freedom, can you talk about any Supreme Court cases that are coming up? I understand there's a major case involving religious freedom that's going to be considered a week after Dobbs.
Absolutely. On the Feast of the Immaculate Conception. How about that? It is Carson versus Macon, and it's a school choice issue out of Maine. Maine, interestingly enough, half of their school districts don't have public high schools. So they have a program where students who live in those districts can go to other schools, whether they be public or private. But there's a catch. They cannot go if the school is deemed sectarian. And the state evaluates whether a school is sectarian if it promotes a religious belief. And so two parents have gone and said that's contrary to the free exercise of religion, and it runs up against a decision by the court 2 years ago in a school choice initiative out of Montana called Espinosa. So this is going to be a very important case. Justice Neil Gorsuch has spoken on this very issue about the importance of allowing families to pursue school choice, even if that includes religious choice, and especially protecting that decision of parents under the First Amendment.
Now, Andrea, thank you so much for your time and always weighing in. We really do appreciate it. Andrea Picciotti-Bayer, Director of the Conscious Project. Thanks again.
Thanks, Tracy.